Here we are. Ooh. Right, good morning, and welcome to this, the first, no, is it the first, second? I don't know. Anyway, just welcome to our first event at Goethe-Institut for 2026. And a huge thanks to the wonderful staff and team at Goethe always. Sometimes I tend to forget them, including our lovely sound and engineering people at the back. We're here for a whiz-bang discussion. There are some members from the platforms who are here. We like to pretend we're a non-violent society, so despite the things that you may hear, we ask that you don't accost or assault them or kidnap them or anything. There are lots of lawyers here, so I'm just covering myself that in case something bad happens. But we're here for a very cool hot button issue around whether or not we should ban or not ban social media for teens. And when we were thinking about doing this, we said, instead of it being a panel discussion, we wanted to have something that's a little bit different, because there are fairly compelling arguments for both sides of this equation. The platforms will tell you, of course, that there's no compelling argument to be banning social media for teens, because they do everything fabulously well, and anything unfortunate that happens is just an unfortunate incident. A bit like Epstein and his unfortunate people that he hangs out with. Yep, went right there straight away. You all know Epstein is, yeah. Luckily he's dead. But still, none of the men have been arrested yet, which is despicable. But I digress. So this morning we're live on Facebook and all of the other socials, which is very cool. Anyway, and discussing it, we said, and Tina was saying, ooh, we should be doing this as a moot. And initially we thought of it as an argument and counter-argument, but a moot is something that those of you familiar with law schools, let's see who's familiar with law schools and moots, by show of hands. Okay, some of you are, most of you aren't, which is why what we've got is an odd setup, right? This is meant to be a courtroom, and once I leave the stage, it becomes a courtroom, and the judge is Judge Karina du Toit, not Justice. I was just told, actually, that's only reserved for Concourt judges, interestingly enough. But Judge Karina du Toit will be here, and she will then preside over the proceedings. Now, normally in a court of law, if you go and you watch from behind, you sit down where you are now, and the lawyers, usually one side or either side of things, and they stand up and they argue. And it's very exciting usually, but you only tend to see the back of their heads, which is usually not very exciting, because lawyers' backs of their heads aren't the most exciting pieces of their bodies. So it's nice if we thought you could actually see what they're doing. So we've kind of put the court sort of sideways for television and social media dramatic effect, because we're all buying into it. So our lawyers are going to come up and they're going to argue from here. Our judge is going to sit over there, and they're going to argue as if this was a normal moot style case. In other words, one lawyer is going to stand up and argue for one side, whether or not we should ban, and the other will then rise and argue the other side. We then have some expert witnesses who are some of our young people. These are members of our Web Rangers teams. They're in the front. And they've been prepared, and they've got lots of fabulous and interesting things to say, so they will stand up and do that. And then Judge Karina will be able to give a verdict on this in between all of this process. So she'll set out how that's all going to work. But we do have a session for allowing a little bit of crowd participation. So to begin with, can we have the screen up, please? So to begin with, I'd like you to all go and visit this QR code that's about to be on the screen. And when you visit there, you'll be able to, there you go. Please scan the QR code and go to the link. Young people with phones, you can pull them out now. Wow, look at how well behaved they are. They were all sitting here, not on their phones. The adults were all on their phones, the young people weren't. What does that tell you? We should probably ban social media for teens. I'm not biasing it in any way or anything, but anyway, right. So here's the QR code. Then what you'll see is we've got 3 questions to begin with. And what word or phrase comes to mind when you think of social media and children or teens? Anything you like, preferably not a swear word though, please. Sorry? What, when you tap on the QR code? Really? Hold on. So it's not working. Oh. Wait. Sorry, I'm just trying to see if I can... Okay. Right. I don't know enough about what I'm doing to solve this problem. I literally have no idea. So, right, scrap that plan. We will sort that out by the time we get to the last version of this quiz. In the meantime, if I can ask you to, by show of hands, so let's just move on to the second question. That was a great word cloud, people. Well done. Can I have the second question, please? Which is, do you think social media should be banned for children? By show of hands, those of you who think it should be banned, put your hands up. Okay. Those of you who think it should not be banned, put your hands up. Ooh. It's, Judge, not appropriate. Right. No one saw that. Luckily, the cameras weren't on it. You've got a hard case to argue. Right, so it's about 50-50 at the moment, actually, which is quite curious. Okay, and then third question is... nope, we'll get to that later. Right. So, without further ado, I'm going to introduce our Moot Court panel now, and I have got CVs. I even printed them out. So, arguing our case, our two different cases, are our wonderful friends from Power Law, Alt Advisory. They're the best if you want to use them. We do all the time. And thank you very much for partnering with us on this. It's really, really cool. And thank you for giving us your staff and colleagues. Thank you for your time and energy that we know you've put into this. So I'm going to call up first Sophie Smit. Sophie is Associate Designate at Power and Associates and is currently awaiting admission as an attorney. She has a BA LLB from WITS and also an LLM in Human Rights Advocacy and Litigation. Sophie works across human rights litigation, research and advocacy, in particular focus on information integrity, digital rights and protection of vulnerable and marginalized communities. Her work engages the intersection of technology, freedom of expression and access to justice. She's a very fabulous person, does a huge amount of work outside of ours. Sophie, please come up. Normally they don't applaud in court, but that's okay. We can here because it's not really a court, right? But you can, I think. Penyo Sakati is someone that we've known for many years as well. Penyo is a candidate, legal practitioner, also from Power Law, surprise. Penyo completed their BCom Law and LLB with distinction at the University of Pretoria and holds an LLM degree in Human Rights and Democratization in Africa from the Center for Human Rights. CHR, some of our friends might be here from there or they're watching online. CHR is also really cool. Penyo has also served as editor-in-chief in the Pretoria Student Law Review, a student-led journal. I mean, that's really cool as well. Thereafter, they clerked at the Constitutional Court of South Africa under Justice Majid. So we've got some really high-caliber people here. Penyo, I'm just summarizing your extensive... There you go, lots of applause. And then I'm going to allow our judge, Karina Dutoy, to come up now. We want to thank you, Karina, for agreeing to come up. Karina is an advocate of the High Court. She's been practicing as an advocate since 2021 as a member of the Johannesburg Society of Advocates. Before joining the Society of Advocates, Karina practiced as an attorney of public interest law, specializing in strategic impact litigation. I've known Karina for some few years. I think I met her first when she was at the Center for Child Law, where she was there for 11 years, from 2006 to 2016. And she then went and joined the Legal Resource Center for some few years. But it's primarily her knowledge and passion for human rights and respect and deep understanding of child rights that we thought Karina would make an excellent stand-in judge for this particular moot. So with that, I'm going to leave you, and we'll hand over to Judge Karina to lead us in proceedings.
Should I just stand there for the beginning?
You can stand wherever you like.
Is this one on?
Sorry, that was a bit bad.
Sorry? Sorry? What?
My colleague pointed out the striking lack of decorum that I displayed when I was just like, okay, now here's Karina. Whereas in fact, of course, when a judge walks into a courtroom, you all rise. So we'll do that again.
No, that's completely fine.
They can stand up and sit down. It's good exercise.
Yes,
Okay,
but maybe
all
it's
rise.
inconvenient. It's okay. Yeah.
There you go.
Please be seated. So I've never really been one for ceremony, so that's okay. You will have, it's a brief CV because I actually made it shorter than that William did. So, okay. Thank you all very much for coming. I'm standing here in the witness box because I'm supposed to give you sort of an idea of what we're going to be doing today, and that looks super uncomfortable to be turning this way. So I'm just standing here for the minute, and then I'll sit and we can go on with the proceedings. So William's already spoken about it being a moot court, but just to give you an idea, how many of you are in fact familiar with moot courts? The lawyers can leave their hands down since I know all of you already. Just a little bit. So moot court is a little bit like a fake case. We have a problem statement or a proposition, and then we have two people each arguing a side. And I think important to notice is that this is an opportunity to discuss and to sort of get young people's views on it. This is not an opportunity to catch people out or to give them a hard time, or I'm reliably informed that I've already been given the reputation of being difficult, but this is not such an occasion. It's not normally when it's a fourth-year law student and it's a moot court, you're permitted to be slightly more mean with a student than you are with actual pupils. So just to say, there's going to be an opportunity for the audience to ask questions, but I would like everybody to please keep in mind the decorum and to ask respectful and kind questions so that we can have a discussion rather than an actual trial, if I can put it that way. So how it's going to work is we're going to have Sophie speak for about 20 minutes. She's going to make a case for a ban. And then we're going to have Pena have 20 minutes, and she's going to make her case why there shouldn't be a ban. In between there, I might ask some questions, depending on what they say. We'll see how it goes. So there'll be a few questions in between, and I'll give them maybe a little bit more time if it got difficult, or, maybe a little bit less time if they're just waffling. So, no, I won't do that. And so then we'll have the expert witnesses, which will be about 30 minutes, 15 minutes each, but it can be a little bit short as well. Don't panic. There's some concern here in the front row. You can be as long or short as you like, except please don't be 2 hours because we must all also go home by lunchtime. And then we're going to open the floor to the audience for a few minutes to ask some questions. After that, we'll have closing arguments, 10 minutes each. And then we're going to have a short break, during which I will make my decision, and I completely haven't made up my mind about what the answer is. So we'll then have a judgment at the end of that. So are there any questions on what the process is going to be, or do we not allow questions? William said it's my court, so I get to decide what to do. I think let's leave it there. I don't know, William, if I've left out anything you want me to discuss about moots. All right, so I think this would have been a more appropriate time for everybody to stand and enter, since this was just an informal indication of what's going to happen. But I think court will start now, so I'll go take my seat. Right. Where's the other mic? Thank you, Ms. Smith. Could you please just introduce yourself, and then you may commence with your argument.
Thank you, Judge. My name is Sophie Smuts. and I am before this court today in favor of a ban on social media. Good morning, Judge. As I've said, my name is Sophie Smuts, and I seek to persuade this court that a social media ban for children under 16 years old in South Africa is constitutionally justifiable, socially necessary, and firmly grounded in international law, as well as South Africa's lived national realities. In advancing this argument, I will address 4 central points. First, I will outline the constitutional and legal framework. In particular, the paramount consideration of the best interests of the child, as protected in Section 28 of the Constitution, as well as South Africa's international obligations. Second, I will demonstrate the concrete harms facing children in South Africa today, including mental health deterioration, exposure to online grooming and sexual exploitation, exposure to NCII imagery, and the dangers posed by AI-generated images, deepfakes, and chatbots. Third, I will explain why digital literacy and voluntary platform regulation on its own will not be sufficient, and why a preventative age-based ban is proportionate and a necessary intervention. Fourth, I will briefly outline how such a ban could be tailored to the South African context, focusing on corporate accountability, practical enforcement, and child-centered protection, rather than punishment. For purposes of this argument, social media refers to digital platforms and applications that allow users to create, share, or interact with content, communicate with others, and participate in public or semi-public online networks. Which social media platforms should be banned in South Africa should be left to the consideration of the state, with factors that I will address later. Second, the word ban refers to prohibiting children under the age of 16 from registering accounts, accessing, or actively using these platforms, while still allowing age-appropriate, supervised digital engagement through educational or supervised online tools. This case is not about resisting technological progress. It is about protecting children in a digital world that is evolving faster than our regulatory safeguards. I would also like to note at the outset that a ban is not the answer to all of the problems that I will expand upon, but it is, I respectfully submit, the starting point. At its core, this matter asks a simple but profound question. When credible evidence shows that children are being harmed in digital spaces, does the state have the duty to act? I submit that our Constitution answers that question in the affirmative, as I will demonstrate. Section 28(2) of the Constitution provides that the child's best interests are of paramount importance in every matter concerning the child. The Constitutional Court has repeatedly held that paramount does not mean one of many factors. It means that children's interests carry decisive weight. South Africa is also a signatory to the United Nations Convention on the Rights of the Child, which obliges states to protect children from sexual exploitation, harmful information, and all forms of abuse. Domestically, South Africa's statutory framework includes the Children's Act, the Criminal Law, Sexual Offences and Related Matters Amendment Act, the Film and Publications Act, and the Cybercrimes Act, which all reflect an existing recognition that children require heightened protection in digital spaces. The question is not whether children have rights online. They do. The question is whether the state may limit access to certain digital environments when those environments undermine their constitutional rights. Under Section 36 of the Constitution, a limitation must be reasonable and justifiable in an open and democratic society. I submit that an age-based prohibition satisfies this test, as this ban only applies to under 16s. It serves a pressing purpose of protecting children from documented harm. It's proportionate and mirrors other age-based bans already in place, such as age limits for alcohol, tobacco, gambling, and other harmful exposures. While freedom of expression is a fundamental right protected by Section 16 of the Constitution, it is not absolute, particularly when the rights of children are at stake. As I have now mentioned, Section 28(2) makes the best interests of the child paramount in every activity concerning them, even online activity. The proposed ban does not prevent children from communicating, learning, or engaging in creative expression through age-appropriate platforms, educational tools, or supervised digital spaces. It merely restricts access to high-risk social environments that have been shown to cause harm, such as exploitation to sexual material, AI-generated deepfakes, and exposure to other serious harms. In this way, I submit that this is a limitation that is proportionate, targeted, and justified. In addition, imposing the ban at 16 years old reflects a constitutionally proportionate balance between protection and autonomy, targeting the period where adolescents are at their greatest developmental vulnerability. This respects adolescents' evolving capacity. It's also consistent with other South African legal thresholds, such as the age of sexual consent, making it a calibrated, rational, and non-arbitrary standard. I will now turn to my second and main point.
Sorry, Ms. Smith, before you move on, I've lost the mic. Before you move on to your second point, I'd like to get some clarity on some of the legal arguments. So let me just understand, when you say a ban, has there been any thought about what the nature of this ban would be? In other words, would it just be that there is a prohibition on using social media, or is it a criminal offense to use social media? And if it is a criminal offense, would it be a criminal offense for someone to facilitate it, or is it just a criminal offense for a child to use social media?
Thank you, Judge. I respectfully submit that in no instance should this be a criminal prohibition. This ban does not seek to criminalize children in any way or online activity. It seeks to hold platforms accountable. I also respectfully submit that the way in which the ban is implemented should be considered by the state, and this court can only guide the state in how to implement such a ban. But we respectfully submit that criminalization does not serve the purpose of the ban.
Okay, thank you. Just on the second question I have was, you mentioned Section 28 of the Constitution, and that's mainly, it seems to me, what you use in your balancing exercise for Section 36. But are there other constitutional rights that attach to children that we should be taking into consideration?
Yes, thank you, Judge. Of course, there are many rights that are implicated in this argument, such as the rights to dignity or protection from harm, security of person, the right not to be exposed to violence, and to be protected. So those are all considerations that have been looked at in conjunction with the best interests of the child. And I didn't expand on them, but the statutory framework that I laid out in terms of the Criminal Law Amendment Act and the Films and Publication Act, all of those speak to the right of the child to be free from sexual child CSAM in particular, and online images. Okay. South Africa is one of the most connected countries in Africa. According to a UNICEF study conducted in partnership with the Department of Social Development, over 95% of children in South Africa regularly access the internet, and 70% do so without parental consent. 25% have added people online that they have never met in person, and 18% have sent photos or videos of themselves to strangers.
So sorry, could you just repeat those percentages for me?
Yes, of course. 95% of South African children access the internet regularly, and 70% of those do so without parental consent. 25% have added people online whom they've never met in person, and 18% have already sent photos or videos of themselves to strangers. 67% of children exposed to sexualized content online encountered it on their own device.
Sorry, and where do these statistics come from? In other words,
When you say 25% of all children in the country, how was, I know we're not supposed to get into too many facts, it's just, it's very important when you're looking at the proportionality.
Of course, thank you, Judge. It was a study conducted by UNICEF in conjunction with the Department of Social Development, and it was a pool of about 2,000 learners that partook in this study, so that is the pool of learners that these statistics are based on. This means that children in South Africa are already using social media unsupervised, exposing them to significant harm long before they are mature enough to handle it. I will now speak to the 3 main forms of harm that children experience online. Firstly, mental health deterioration. Second, exposure to child grooming, exploitation, and NCII abuse. And thirdly, how algorithmic amplification informs all of the above. Turning to mental health and psychological harm. In South Africa, the South African Depression and Anxiety Group has reported rising levels of anxiety and depression among young persons, with online comparison culture, cyberbullying, and algorithmically amplified content playing a significant role. The same study conducted by SADC found that 1 in 5 teenagers had experienced cyberbullying firsthand. Eating disorder content is widely accessible on major platforms, despite content moderation policies. Hashtags and coded language continue to promote finspiration, starvation techniques, and body comparison trends. For vulnerable children, especially girls, this can be particularly harmful. Self-harm content is similarly persistent. The tragic death of Molly Russell in the United Kingdom, whose online feeds were saturated with self-harm material, led to the coroner formally linking algorithmic content exposure to her death. While that case occurred abroad, the digital platforms concerned operate identically in South Africa, if not with lesser restrictions. These harms are not theoretical, they are systemic. The second and most pervasive form of harm facing South African children is child grooming, sexual exploitation, and NCII. Online grooming remains pervasive. A national study, Disrupting Harm in South Africa, again conducted by UNICEF, found that 7 to 9% of internet-using children aged 9 to 17 reported sexual exploitation online in the last year. This included being offered money or gifts in exchange for sexual images or in-person sexual activity. In addition, the non-consensual intimate image sharing abuse disproportionately affects girls. Once an image is shared, it is very difficult for it to be removed. And even where content is removed, copies proliferate. The controversy surrounding Grok, developed by XAI and integrated into X, illustrates how AI chatbots and image systems can be used to generate explicit sexual content, including of real individuals. Innocent images scraped from public accounts can be converted into highly sexualized or degrading material. For children, the consequences are devastating. This includes reputational harm, bullying, blackmail, school expulsion, and severe psychological trauma.
Tell me something, Ms. Smith, what is the difference between being exposed to this on social media and simply picking up a sexually explicit book, for instance?
Thank you, Judge. The difference is that the platforms themselves are failing to regulate online content. And so by implementing a ban, we are trying to get a host of stakeholders involved in prohibiting children from accessing these materials. Accessing a material inside a bedroom or in a home carries their own prohibitions or sanctions, but currently there are no prohibitions on sanctions on online activity. If such a material was found in the home, a parent or an adult could be held responsible. On a platform, currently, no one is being held accountable for exposure to such material.
Yeah, I'm sorry. I'm just thinking about when I was 12, which is a very long time ago. It's before dial-up internet even. And there was, I mean, I don't want to make my parents sound bad because they were very good parents, but very rarely do we, I think, when you have regular children sort of not, what's the word I'm looking for? Not exhibiting any risk factors or anything. I think that there's very little oversight about the kind of, if you're talking about old school hard copy books now, that can be read. I don't know how much regulation there really is about what you can pick up and read. So for instance, there are these books at the moment that are out by Sarah J. Maas, which is what we like to refer to, I apologize for anyone who might be offended, we call it fairy porn, because it is books that pretend to be youth or a young adult that is about fairies, but it is pretty graphic sexually. And we see children getting box sets of that for Christmas who are 14 years old because it's fantasy and it's got fairies and whatnot. And I don't think parents know what's in those books. And so my question is, on a psychological level, what is the difference between being exposed to that and being exposed to sexual contact online?
Thank you, Judge. I submit that there isn't a difference, and the difference is in who is being held accountable. And I don't want to put before this court that because one aspect isn't being efficiently regulated, that we shouldn't now regulate online content. The fact is that our children are being exposed to a wide variety of harms, both online and offline. And what this ban seeks to do is to protect children online. And other discussions need to be had about how to protect children in the broader sphere. But just because they're not being sufficiently protected for hard copy doesn't mean that those should follow through to not banning online activity. Okay. Lastly, algorithmic amplification informs all of the...
We need to move on to your other 2 points.
Okay.
I know I've taken up a lot of your time, but I have given you it.
No, that's fine. Thank you, Judge. I just want to make the point that children are not only exposed to harmful content, but they are algorithmically steered towards it. Now, with all of these harms in mind, I want to briefly address why voluntary platform regulation and digital literacy training alone are insufficient. It will be argued that instead of a ban, we should invest in digital literacy. Digital literacy is important and should absolutely form part of the solution, but this is a false binary. We can still draw the line at 16 and invest in digital literacy, strengthen parental awareness, and increase platform accountability. Digital literacy teaches children how to navigate online spaces. A ban reduces early exposure to hazardous environments themselves. We do not respond to an unsafe road only by teaching children how to cross it. We also install traffic lights, fences, and age limits. South Africa has already implemented age-appropriate bans, as I've mentioned, on alcohol, tobacco, driving, gambling, and sex.
I just want to clarify this point because I care. It is not actually a criminal offence for children to either smoke or drink. It is a criminal offence to serve children or to sell them alcohol, but it is not a criminal offence for children to drink alcohol, nor is there a prohibition on it. It might be bad parenting, it might be many things, but there is no actual law that says a child may not drink or smoke. You may just not sell them or serve them any of those things.
Thank you, Judge. The closest kind of law that I do want to draw a comparison to is sexual consent, which is drawn at 16. And so if we just look at that comparison, it's just to say that this is a proportionate ban that has already been implemented in some ways offline. Just to end off with a South African approach.
I promise I will be as difficult with your colleague as I am with you. But again, I want to point out that sexual contact is only prohibited when it is with an older person, not when it is with someone who is in your peer group. In other words, if you are both 14, then there's no prohibition.
Okay, thank you, Judge. Although international precedent exists, we must not follow it blindly. Our regulatory response must reflect South African realities. As a starting point, we must target platforms that are relevant to South African youth. Legislation should focus on platforms with significant child user bases in South Africa and platforms that have been documented to show harm. We also need to address AI and chatbots, something that Australia's legislation hasn't done. AI-driven chatbots and generative systems are increasingly interacting with minors. Globally, there have been cases where AI systems encouraged self-harm, engaged in sexually explicit conversations with minors, and reinforced harmful ideation. In the South African context, enforcement could include the following: mandatory age verification requirements, significant administrative penalties, and collaboration with mobile network providers. I also want to add that public education campaigns aligned with departments such as the Department of Education, of Law, of Justice, and DCDT are also important to get public buy-in. Because we're not looking at criminal prohibitions, we need to get the public on board with the ban so that it is not about criminalizing children, but rather about holding platforms accountable. In conclusion, this court is not being asked to ban children from the digital world, but to protect them from environments that have and will continue to cause them harm. The proposed age ban over social media is targeted, proportionate, and grounded in South African law. Section 28 makes the protection of children paramount, and in the face of credible evidence of harm, the state has not just the right, but the duty to act. For these reasons, I respectfully submit the ban is constitutionally justified.
I have one more question. I just want to understand your ban. Is it aimed at saying that service providers or platforms are not permitted to register children, or is it supposed to say children are not allowed to be on it or use it, or is it both? I just want to know, because you say that it's aimed at platforms. I actually don't know if I'm qualified to do this court because I'm not on any social media. And so I don't know what the exact terminology is. So just explain to me, who is the ban aimed at?
Thank you, Judge. At the beginning or the outset of my presentation, I said that the ban refers to platforms must prohibit children from registering accounts, accessing, or actively using these platforms. So it's both of the situations that you've referred to. Many of the platforms, for example, that Australia has banned can be used without having an account itself. And so the ban needs to incorporate ways of stopping children from registering accounts. And just to say that the purpose of this would mostly be to stop children engaging with other users. And so if they can use a platform and maybe not engage in a way that would be harmful or exposes them to child grooming or the identified harms, the state would have to consider that.
Would this include PlayStation chats, or is that something you're leaving up to the legislature?
I submit that the state needs to do a study. I looked at the top 10 most used social media platforms in South Africa, and that didn't cover any type of gaming chat rooms. But I was looking at what Australia did. But I respectfully submit that the state needs to conduct these investigations and see, the two criteria should be which has the largest child user bases and which platforms or apps have documented harm against children.
Thank you so much.
Thank you.
May it please the court, Judge Dutoy. I am Pena Sakati and I appear before the court against the ban on social media. South Africa does face a genuine risk with regards to online harm, and it affects everybody, including children. Young people are indeed exposed to cyberbullying, predatory content, and age-inappropriate content on social media platforms. South Africa, like the rest of the world, is seeing this and is trying to collectively grapple with this issue, as it should. Banning social media is, however, with respect, not how to do that. My argument is structured around 3 submissions, namely rights, safety, and practicability. First, from a rights-based perspective, I'll argue that rights-based frameworks support safe participation, not prohibition. You do not have to protect children by raising their voices. Secondly, From a safety perspective, I will show that current evidence does not support banning, but rather teaching, guiding, and building digital resilience. And last, I will show that as it stands, a ban is impractical, inequitable, and fails to address the root causes of online harm. Unless the court will otherwise lead me, I will proceed with my first submission, which is that rights-based frameworks as they stand support safe participation, not prohibition. Children are independent rights holders with a protected right to freedom of expression, which includes the right to seek, receive, and impart information and ideas. And this is outlined in Section 16 of the Constitution. A social media ban strips children of access to the primary channels through which information now flows. Now, as indicated by my learned colleague, under Section 36, a right may not be limited unless the limitation is reasonable and justifiable. Another factor that my learned colleague has not mentioned is that it must be the least restrictive means employed. Blanket ban does the opposite. It is broad, it is blunt, and necessary. And it is unnecessary because there are targeted, less restricted tools that exist, and these will be discussed further in my submissions. International, regional, and South African child's rights law also recognizes the evolving capacities of the child, as was noted by my learned colleague. Article 5 of the Convention of the Rights of the Child, the CRC, places a responsibility on and expects parents, the state, and private actors to support children's gradual assumption of agency. And this is echoed in Section 7 of the Children's Act, in South Africa's Children's Act, which lists a child's age, maturity, stage of development, security development needs, and the likely effect of any change in the child's circumstances when considering the best interests of the child's or factors pertaining to the best interests of the child. A ban contradicts this premise by freezing capacity and denying children opportunities to learn safe and responsible ways to participate online. The United Nations Committee's General Comment 20 on the implementation of the rights of the child during adolescence frames adolescents as agents who must be empowered to participate and be included in digital and social media environments. This kind of empowerment presupposes graduated exposure, not prohibition. And for judges' reference, this is in paragraph 2 of the general comment. Further, general comment number 25 on the rights, on children's rights in relation to the digital environment clarifies that all rights under the CRC apply online and that states should ensure design-level safeguards, literacy, and accountability mechanisms so that children can exercise their rights safely in the digital environment. Again, this favors protection by design in digital environments and not a blanket ban that ultimately silences children. Children also have the right to access information from diverse national and international sources, and this is outlined in Article 17 of the CRC. Those have the right to be heard and to participate in matters that affect them, Article 12 of the CRC. Whether we like it or not, social media is now the primary vector for information, association, and even education. The United Nations High Commissioner for Human Rights and UNICEF have both emphasized that children's rights apply fully in the digital environment and call for rights-based regulation, content moderation, transparency, safety by design, data minimization, and robust redress, all of which address online harms without diminishing the voices of children. In short, our Constitution and our current legal frameworks just do not simply support a ban. The laws as they stand ask for proportionate rights-respecting measures. My learned colleague has failed to show how, not seen how this is the least restrictive mechanism. My second submission on current evidence that safety sort of consideration and cause
Sorry,
for...
Ms. Sakati, I think this is a good time to perhaps start. I think what I would like to understand is, I didn't understand your colleague to talk about a blanket ban. I understood her to say there would be a ban under 16, but with some educational exemptions, but you can correct me if I'm wrong. It isn't entirely clear. I think we're working in a bit of a vacuum in the absence of having a real proposal for a ban. But my second question is, what other rights, apart from Section 28, apply to children that ought to be relevant in these circumstances? Because I've heard Section 28, which incorporates the child's best interest and the right to be heard, but I don't believe that those are the only relevant rights at this stage. I think that there are others. So if you could please address me on some of the other rights that apply to children.
May I please the court? Judge, on your first question, it is quite difficult to understand and to locate where this ban would sit. And so we draw inference from examples in Australia, France, and Spain, which I will get to on what they have imposed. While the ban proposed by the proponent is not a blanket ban in the sense that people can access online, the internet, it is a blanket ban in the sense that children will not be able to access social media platforms. If this ban then also extends to chatbots, then one would have to then again assume that these chatbots apply to gaming platforms, etc. Again, it is very hard to determine what this ban would look like in the absence of any clarity to the effects. But if we draw inference from the 3 countries that have done so, it has been considered as a blanket ban in the sense that children are unable to access social media platforms. And on the second question, Judge, I draw reference to the right to access information, freedom of expression, as well as sort of as a catch-all consideration to the evolving capacities of a child. But these rights do not only necessarily feed into Section 28, but are also considered as standalone rights, and that is why they were mentioned accordingly. On the second submission, the safety case for a ban sounds intuitive, but when you look at how countries are actually doing this, and while child experts say, we can kind of see how the notion of a ban is an ambivalent approach where better options like platform accountability, building real safeguards, and teaching resilience should rather be favored. So what is actually happening in these other countries? And I think that this will also address Judge's first question. The 3 countries that have made the greatest strides towards the ban are France, Spain, and of course Australia. In France, lawmakers have put forward an under 15 ban. And this ban, while not clarified, has already been met with several concerns, specifically with how easy it may be for children to circumvent this ban through the use of VPNs. Moreover, on the 26th of January 2026, 9 child protection associations had approached government lawmakers to hold platforms accountable and not ban children from social media. And so from this, we see that the approach that France is taking is more sort of a blanket ban. In Spain, Prime Minister Pedro Sanchez announced an under 16 restriction built on effective age verification and shared responsibilities, which places the duty on platforms and on families. So this is similarly, again, to what my learned colleague has envisioned. But there have been concerns there as well, and this also brings about some of the concerns that we are dealing with today, is what counts as social media? Will chat functions inside games be included? Will encrypted messaging apps be exempt? And these unresolved gaps have to be addressed at the forefront, otherwise they undermine sort of the idea of a ban altogether.
Sorry, Mr. Gati, can you please just explain to me, because your learned colleague mentioned that technology is developing faster than the regulatory framework. And what concerns me in the court is that, you know, there is significant evidence of children being exposed to material, being groomed, being exposed to chatbots, that sort of thing with, you know, and so I think I would like you to persuade me to some extent that there is sufficient safeguards, that there are sufficient regulatory materials. When you talk about alternatives to a ban, what are those? Because I think it's in the nature of adolescents to be secretive and to try and circumvent, you know, boundaries, because that's what adolescence is about. It is to push boundaries. And so, you know, having frameworks in place is not necessarily it's more like a challenge than it is, you know, a prohibition, if you understand what I mean. And so I would like to understand that there are appropriate safeguards if a ban isn't appropriate.
To address your question, Judge, I have 2 points. Firstly, and I suppose this sort of speaks on the impracticality of the ban in and of itself. If children are able to circumvent if children are able to circumvent, find themselves online in any event, it questions sort of the usefulness and utility of the ban. But moreover, we also, sorry, Judge, may you please repeat the second part of your question?
How can we be sure that there are sufficient safeguards and that a ban isn't the appropriate way to go? When you're talking about less restrictive means, and you say, and your colleague says that the regulatory framework can't keep up with development, how can you put the court at ease that there are sufficient mechanisms and that a ban is an overreaction?
Judge, I think on that point, it is important to note that a ban, when imposed, should this ban be imposed, it would be restricted to the age of 16, and my learned colleague has made that clear. After that child then turns 16, 17, and they're exposed to online content, if all we do is impose a ban, these harms will still be there. Non-consensual intimate images will still be there. Cyberbullying will still be there. Online harassment will still be there. Now these children will just have to be exposed to that after having years of no exposure, no digital literacy by way of engagement with these social media platforms. And some of the measures that have been proposed is safety by design, data minimization, and enforcing more content moderation transparency. And while it is acknowledged that that there is still work to be done in these respects, it is with respect also submitted that these approaches are firstly able to be implemented at a faster sort of pace than any regulation that would be banning social media could do. So therefore, responding to Judge's concern on technology developing faster than regulatory frameworks. And secondly, it does so without completely removing children from a space that they will then have to reintegrate themselves into at a later stage. And if the ban is the only sort of proposal in this instance, without additional measures being put in place, they effectively go back into the same space that they left, with less tools on how to navigate said space.
I think you must move on to your point on practicability, please, Ms. Sakati.
As it pleases the court. On the point on practicability, my third argument is that a ban is impractical and inequitable. What the proponent proposes is a surface level intervention that looks like action, but does not actually remedy the actual problem. And we've seen this with sort of the international law examples that have been given. Australia is one such example where teenagers have been able to bypass age verification tools with simple facial scans and improvised adult IDs. France is dealing with the issue of children bypassing these verifications through the use of VPN. And if children in these sort of better resource countries that are more digitized are sort of slipping through the cracks, as it were, it is with respect almost naive to assume that South Africa, with far weaker enforcement capacity, would achieve better results. And this leads to the question of whether we are importing European solutions into an African context where basic assumptions do not hold. Much of the global legislation and the bills that are being drafted presumes that platforms have offices in their country, that governments have strong cross-border enforcement capacity, and that digital infrastructure is robust. None of these presumptions are true here. Most major platforms do not even have physical offices in South Africa, meaning enforcement mechanisms like fines and audits and compulsory age assurance are largely toothless in practice. And then there's this glaring inconsistency. These bans do not speak, and my learned colleague does not speak on the issue of sharenters, family bloggers, kidfluencers, where parents are in charge of these accounts and have led to, and where this has led to parental exploitation. Yet children's greatest documented privacy violations often come not from strangers online, but from adults who control their content. Worse still, the proposed age verification mechanisms are not just impractical, they're also deeply exclusionary. And while my learned colleague has not given sort of an overview as to what this would look like, we can draw inference from countries that have imposed this.
Sorry, Ms. Sakati, can you please just explain to me what is the value of social media platforms? Because it seems to me that your argument and your learned colleague's argument is centered on everything that is wrong with social media. And from the evidence that has been presented, it seems to me we may as well ban it because it is no value but holds a whole snake bit of dangers. So what is the value of social media for children? Why would we not ban it if it is so awful?
There are many benefits to social media and using social media platforms. And this was outlined sort of at the beginning of my argument to say that social media has become a primary vector for sharing information, for fostering community, and even has been a tool for children to access educational content. This is also a platform whereby children are able to engage with with their peers, where they're able to engage with information that they otherwise would not have access to. And this is all mentioned at the beginning of my submission to say that children derive information from diverse sources through social media platforms. There's that sense of community, and there's an educational benefit to it as well. Just to wrap up my arguments, to say that proposed age verification mechanisms are also impractical. They're deeply exclusionary. South Africa does not have universal digital ID coverage. Large portions of the population, especially rural, undocumented, or economically marginalized communities, lack reliable ID and sort of any system that would require one to produce an ID or passport, etc., to verify their age would disproportionately exclude certain groups. And the alternatives, and this brings me to my final point, the alternatives are much more troubling. Face or voice recognition tools that could be used to determine age will depend on training data sets that are notoriously biased, specifically, particularly against African populations. So requiring individuals to submit biometric information introduces privacy and security risks. And again, the questions still arise. What training data will be used? Who will be storing that data? How will it be predicted? And how do we prevent biometric profiling? None of these have been addressed. And ultimately, sort of these submissions returns us to the heart of the matter, which is that a ban strips children of autonomy without solving any underlying issues.
I'm very, very sorry, but I mean, you just mentioned data storage. Isn't that a problem in general? I mean, is face or voice recognition really going to add to significantly add to what is already basically living your life online and having, I mean, if I talk about cat beds, my phone hears it and I get ads for cat beds when I do internet searches. So I'm not convinced that face and voice recognition is going to violate your privacy already, more than it already is.
To be able to impose a ban of this nature, there would have to be a lot more sort of digging in that these social media platforms would have to do. For example, in Australia, social media platforms will now face a fine up to 45.9 million Australian dollars if they do not impose sort of sufficient mechanisms to verify, to ensure that under 16s are not on these platforms. As it stands, Australia has recognized that this would require platforms to do more than what they are currently doing. So, yes, while there is this issue of personal information being stored and used, platforms, we don't want to add to the issue, and we definitely do not want to exacerbate it, especially where children are concerned. And to summarize, to finalize my submissions, a policy or proposal that is unworkable, unforceable, and exclusionary, and is misdirected insofar as it burdens children while leaving platforms, algorithms, and harmful design features, which are the real drivers of online risks, unchanged, cannot be said to be in the best interest of the child. And unless the court has any other questions, this concludes my submissions.
Thank you so much. Are you going to be calling the witnesses? Maybe.
Morning. My name is Moxii. I am a student at Macaulay House High School, and I am 15 years old. I am also a web ranger and a member of the Article 12 Policy Working Group.
I'm terribly sorry. I was just conversing with my clerk over there, the registrar. Could you please repeat your name? Oh. I missed that when you started speaking. I'm so sorry.
My name is Moxii. For those who don't know, the Article 12 Policy Working Group is made up of Web Ranger ambassadors who have been trained in digital literacy and have an interest in policy work. All of the Article 12 members are children ranging in age from 13 to 17 years old. Article 12 members engage in ICT-related policy submissions and discussions that ensure that their voices are heard and opinions are considered by policymakers and industry leaders. Yes. So, I would like to say that I am somewhat neutral in terms of the ban, but I lean more towards a positive side. I would like to firstly list the positives of social media, as the judge has mentioned during Ms. Sikati's argument, that she feels as if she's not sure what the positives are. So as a person who's actively on social media, I would like to state them. First of all, it's connection and belonging. As teenagers, I'm going to be completely honest, we are pretty close-minded. We have our own communities and our own groups. In movies, you'll see it in cliques, for example, Mean Girls. social media provides an environment or an atmosphere for different people to find their communities, whether it be the emo kids who feel as if in their environment they are not accepted, but on social media they might find someone who has the same interests as them. So social media brings connections and belongings for teenagers so that they do not feel lonely or feel ashamed for who they are. This brings me to my next point of allowing creative expression and identity. Social media allows us to find our expression and our identities when we are not given the platform or the places in our atmospheres and environments. It gives us a chance to explore different sides of ourselves, explore different people, while also expressing our creative ideas and our opinions. In that, you are able to also access information and learn because you are exposed to different opinions, different mindsets, and it also allows you to be more open-minded to different people of different opinions. It also provides mental health support. As a teenager, you are exposed to different emotions and feelings. Personally, school gets a lot, even for me, and social media has helped me in a lot of ways, more than anyone can imagine. In social media, in a comment section on TikTok, I can find someone who can relate to anything that I might feel, whether it be struggling to understand maths, not knowing what I want to do in the future, not understanding how I feel about certain things. In that way, I can find support even in a random internet stranger, the same support I cannot find in my peers around me. It also allows empowerment and advocacy. It allows us teenagers who feel as if we do not have the platform to voice our opinions to actually be able to voice them and find people who will actually hear. This allows us to be able to develop our skills and our mindsets, which is very crucial during adolescence. Now, I know everything that I have said clearly sounds like it comes from Google, which it does, but I would also like to speak on what Ms. Smith and Ms. Sakati has also mentioned during this. I am personally more so leaning towards not having the ban. Because honestly speaking, adolescents will always find a way around things. So banning it will do genuinely nothing. I say that I use the example of TikTok. If I'm not mistaken, in 2020 to 2022, TikTok raised its age restriction to 13. People under the age of 13 were not happy about this, so they resorted to another platform, Likey. I personally, at that time, also resorted to that platform. That platform was not safe in any way. This means that if adolescents now find different alternatives, those alternatives will not be safe to them. Likey was a place where a lot of pedophiles and perverts were able to find child victims because a lot of them were there and thought that it would be a safe place for them because there weren't any adults, but they were wrong. Hence the reason why I think that social media should not be banned, firstly, because we will find a way to enter it. For example, the teenagers in France, they now have access to VPNs. They can use VPNs. So in any way, using a ban does not change anything. And I understand and hear Ms. Smith's point in the terms that it protects our children and the youth, but does it really? Because when we are now exposed to all of this when we are 16, after not being exposed to it at all, it'll become genuinely overwhelming. Hence the reason why I personally believe that it is important to actually have exposure therapy to social media rather than just bombarding it on teenagers. As a person who uses social media and got a cell phone and social media pretty early on, I could say that I was not introduced to social media. It was just thrown into me. I just went into it. Anything that I have learned, anything that I now know about social media, I had to learn from experiences. I was not taught. And I understand digital literacy, but all digital literacy genuinely does, it tells you what to do and what not to do, but also not necessarily the harms and the risks that might come with it and what you might be facing there and what you should prepare yourself for. So in terms of digital literacy, I feel like schools should focus on that more. Also, like the judge mentioned, adolescents they usually push boundaries and are usually very secretive. Hence the reason why I genuinely do not believe that a ban will work at all. And though a ban is supposed to protect children from harm and all of those things, the harms will still be there. a ban will not cause those harms to just disappear. What is most important is teaching our children how to handle social media, how to be good digital citizens, and know how to actively be good and aware digital citizens as well. For me personally, I would like to also say, in terms of advocating for the ban, I think the ban should be for children under the age of 13, but restrictions should be put in place for children 13 years and older. The reason I say this is because I got my phone when I was 12 years old, meaning that I was exposed to social media at that age as well. And I can say it had a pretty big impact on my life. Before I got a cell phone, I read a lot. I was able to think for myself, and I was a very active student. And I'm not saying that it influenced me to not be the same anymore, but I can definitely say that there is a change. I find it difficult sometimes to think of answers for myself. I find it difficult to be able to even articulate better things. My vocab has been somewhat limited to the books that I stopped reading when I got my phone. So I think that it is important for children under the age of 13 to be more so exposed to being a child, an actual child, not forcing themselves to grow up due to social media. But when they turn 13, I feel like they should be monitored. Not saying that they should not have access to social media at all, but it should be monitored. They should be able to know how to balance schoolwork and all of those things, while also being able to be on social media, interact and participate in fun trends, and so on. So that is my argument, that the ban should actually be for children under the age of 13, but restrictions should be put in place for children 13 years to 17 years old to ensure that they are able to use social media the right way, and also be able to, so that they are not just exposed to it in that way once they finally have it. Apologies for where I'm structuring my points. I had a lot of things to say, but I hope that everything that I'm saying currently makes sense.
You're well within time.
Oh, ma'am, I wanted to ask if you had any questions.
Sorry?
Any questions from the judge? No. Okay, thank you.
Good morning, everyone. My name is Mulai Matao. I am an Article 12 member from St. Matthew's High School. And as my colleague said, Article 12 are basically children who are well equipped with media literacy skills. We use these skills to basically educate our peers on safe internet usage, and also to challenge certain, how the media is shaped, challenge certain, that's what we basically do. Now, my stance on this matter, I'm pro the ban of social media, mainly because of how the freedom of expression is used, you know. Freedom of expression shouldn't be a bad thing, but in various social media platforms such as TikTok, you see that they use it to a misadvantage, or they don't use it properly. A community I like to reference is the Black Pill community. Fortunately, I am chronically online, so I know a lot about these. So the Black Pill community is basically a community where they've developed a certain standard on an objective manner of how a person should look like. So how can you gain merit, or how can you develop yourself into befitting in this community while you take part in ridiculous acts of striking yourself with various objects in order to change how your facial structure is formed, and you basically, it's supposed to be empowerment, but it's gone wrong because it empowers some people for their confidence, but also doesn't acknowledge the fact that it's doing harm. My other argument for the banning of social media is that it is the various, I'm still sticking to the various communities. Also, there's this application called Reddit from my experience, it's far too easy to have access to Reddit as an adolescent. All it takes is just a simple download from the App Store or Play Store, and then you can simply lie about your age. Reddit is primarily supposed to be used for adults. Its content can be filtered for teenagers but it's not for teenagers under the age of 16. But they can just bypass it by a click of a button. So I don't think much has been done to really regulate the moderation there. It's poor. It's very poor. Now, why I'm so touched by how poor the moderation is when it comes to Reddit, it's because you can access literally any form of explicit imagery, any form of graphic media can be accessed on it. It's just that simple. It takes a click of a button to just access that piece of media, and then you're there. And then you think to yourself, why hasn't there been why has the moderation been so poor? You know? And then my second argument is mainly because of social media takes the core of what it is to be a child. I feel like it forced me to grow up in a quick manner. In order for me to relate to some things, I had to grow up quickly. It didn't give me a platform to be a kid, because most of the people on social media are either adults, young adults. There are no kid influencers that talked about toys or anything. It's mostly adults that spoke about getting money or trading or anything like that. And as a kid, it's so harmful, because when I look at myself right now, as compared to when I was a kid, I see two totally different people. Right now, I feel as if I am an open-minded person, open to a belief. What I believe in can be challenged, and that's okay. But back then, with the type of content I watched on social media, it felt like it was the objective standard of how human beings are supposed to behave. Now, with that, it's very harmful for a child to have quick access to this, as it's very hard for a lot of children to leave that mentality. It's very hard. Even some of my peers still exhibit some of those. You can easily see that they have been influenced. They don't have an open mind about anything. And it's mainly because of the trends. And another point, like the freedom, going back to my point of freedom of expression, sure, it's supposed to be like that. We're supposed to be a country that is pro-liberty. Everyone has the freedom to do anything. But that should come with certain restrictions and regulations on what you're supposed to post. I remember stumbling upon a post about someone who's pro the old apartheid flag about South African flag. I don't know, that was during the apartheid era. And then I did like any digital citizen would, reported the post. By my surprise, this post isn't wrong, or it corresponds with their terms and conditions when it comes to the media. So it comes back to the poor moderation that comes with these apps. Now, banning social media, I feel like it doesn't mean that children are in the wrong. There should be some common ground when it comes to educating children about digital media literacy skills, and also there should be certain steps that are taken and certain measures to ensure that social media becomes a safe place for everyone. This ban isn't something to be used to restrict anyone, to shut the mouth of anyone. It's simply a period where social media is under construction to ensure that it is safer and children can benefit from its use. My last point, social media is a very engaging place. It's a very fun place. I won't lie and I won't have a certain bias because I'm pro the ban. I use social media a lot. I use it for my studies. I use it to engage with friends. I use it to learn more about myself and the world around me, the environment around me. Banning it is wrong, because you're limiting children from experiencing what I've experienced. And by me talking right now about I'm pro-ban, but I've been able to gain something from it, it would be completely illogical. So yes, I understand that it comes with its downsides, banning social media, but I'd like to stress that it's not a permanent ban. It's only a period. It's supposed to be a period where social media becomes under construction to ensure that the usage is safe. Thank you.
Thank you so much. Okay, I think it'd be best perhaps if I moderate from there. Do you two mind bringing some chairs up and sitting up? You can sit on this side if you like, if you don't want to sit with the lawyers. We're going to do a small session now, just with if there are any questions from the audience. And you can ask anyone except me questions. I might comment. Okay. Right. Does anybody have any questions, either for the witnesses or the legal representatives? Or you don't have to have a question if you just want to express an opinion or a view, or whether you want to have a ban or not have a ban. You can also do that. Sorry, what? Okay. All right, go for it.
Good morning to the judge, the legal representatives, the witness, and the audience. I have a question for Ms. Smith regarding her decision to go for the ban. I wanted to ask, why do you think it is the responsibility of the child and the child's fault for all the horrible things that happen on social media? Because that's my understanding of the ban, to protect the child, even though it is not a child's fault for seeing sexually explicit material on social media, especially since your basis of the ban is to ban it from under the age of 16. And in South Africa, the age of consent is 16. So regardless if the child, when the child sees that and they're younger than 16, it is obviously going to be the fault of the person who created that sexually explicit material. And also it is the fault of the accounts that, like, for example, you used accounts that promote ED culture and self-harming culture. Those accounts should be the ones held legally responsible, and those accounts should be the one taken off social media instead of the child. And it reminded me of the situation in South Africa with shade rooms, where personal and private information was shared publicly about students in those shade room accounts. And I'm not so sure, but I don't think any of those accounts were held accountable, but instead the victims of those shade room accounts were shamed and saying, why would you send this to someone else? Thank you.
Okay. Thank you. That is a really great question. I want to start off with saying that it is definitely in no way the fault of the child. Whatever happens to a child or whatever content a child is exposed to is by no means the fault of the child. And you also answered your question where you said it's the platforms that should be held accountable. And so the argument with the ban is the fact that the state has a duty to act in this situation. Children are being exposed to harmful content online, and so the state has to do something. And that's what I started off with in my argument, is to say that the ban is not going to solve every single problem presented here today, but the ban is the starting point of the state doing more than digital literacy and more than safety by design. It's not happening. The case of Molly Russell happened over 5 years ago, and exposure to self-harm content is only worse. And so the ban is the state's way of taking the duty that it's supposed to take.
Right, I think your friend next to you had a question. You didn't have one? Oh, right. Okay.
Oh, thank you so much for the really informative and well put together presentations. Thank you. I really appreciate the input, especially from the youth, because I think just to hear your perspective is so helpful. My concern, I think, around the argument about not banning social media for under 16s, Ms. Sakati, I feel like there's a kind of a false dichotomy that we're creating, in the sense of a lot of the arguments are around the fact that platforms need to take responsibility themselves and accountability for their own content. And that actually the ban kind of counteracts that. And I think that actually is probably untrue, in the sense of, in fact, the ban is designed to hold those platforms accountable and to ensure that they do take consideration of their content. And I think what's very important to understand is that digital platforms know the harms that their content is creating. In fact, there have been leaked documents over a series of years that have come out of a number of these organizations like Meta and TikTok and others, where they've done very intensive work looking at the addictive qualities of the content, at harm in terms of exposure to online grooming, creation of child sexual abuse images and material. All of these things are evident and known to those platforms. They have had opportunity to be able to change their design, but in fact they've pulled back from it. In many cases, like for example with X, we've seen that they've got rid of their safeguarding teams. So in fact, they've gone in the opposite direction. So I think this, in the sense of it may be a blunt instrument, but it's very much looking at how do we take what is a very unaccountable set of organizations and hold them to account to some degree or another. So just to reinforce, in my understanding of what Ms. Smith was saying and what the ban is in other countries of the world, it's very much around placing the onus on those social media platforms and applications. It is not in any way intended to penalize children, or in fact their families. And I mean, I would argue it's probably not a fair fight. We use digital literacy to say, well, children must keep themselves safe, but they're up against very, very well-designed algorithms and very, very sophisticated platforms that have spent a lot of money on creating and ensnaring children into these platforms. So anyway, sorry, this is a very long statement, but what I just wanted to say was, what was very, I think, informative for me was during the Grok incident at the beginning of this year, one of the things that X said was they would geo-block harmful applications from countries where there was regulation. And I think that was a very, for me, that was a very significant statement, because effectively what they were saying was they have no accountability unless we hold them accountable. And so my question is it fair to say that a ban is in fact taking the onus away from them, when I would argue that actually it's exactly the opposite, This is what we need to universally, because other countries are going to pull back from it. And my concern is that those organizations are going to drive into markets like ours, where we don't properly regulate and take care of our children.
Hello, I'm William Bird. I just wanted to, there were two issues that I'd love to hear from either in response or in their closing. We haven't touched on information integrity in relation to young people and either to ban or not to ban. So this is about people, and young people particularly, having a right to access information that is credible and accurate, that they can use to make informed decisions. And with AI, we see that the ability to invent and hallucinate, make up almost anything, is increasing. We no longer know what's real and what isn't. That's my first thing. The second thing is, we both talked about age verification and being able to get around it and using VPNs, and then saying we need retina scans and biometrics and all of this kind of nonsense, right? Whereas in fact, the platforms already know exactly how old every single one of us is in this room to the millisecond, right? To suggest that somehow they don't, and that they're putting forward this idea that, oh, they can't do an age verification, it's really hard, the technology's not there yet. Like, I think we're letting them get away with that, and I'd love to hear your thoughts on the implications of that for both to ban and not to ban, because there's no way they don't know exactly how old every single one of us is.
So they're going to reserve that for closing. Are there any other questions or comments from the... Yes?
I have a couple more statements and a few questions. One of my statements is I relate to what Ms. Sakati said regarding that we, as South Africa, we're trying to use European solutions to African problems, because I remember last year when I was first introduced to the Article 12 Policy Network Group, one of the first things that we learned was that in first world countries, mostly in Europe, when you sign up for an account on Instagram, automatically, if you are under the age of 17, your account is private until you turn 18. Whereas in South Africa, that's not the situation. And as well, I understand when Ms. Smuts says, Ms. Smith says that digital literacy is not always sufficient enough. And my point of view comes from the fact that in South Africa, we have 13 official languages, and in almost all digital platforms, you are unable to read the terms and conditions in the indigenous languages of South Africa. So when a child signs up for that social media and they do not fully speak English or the languages that the terms and conditions contract is translated into, they won't fully understand what they're getting themselves into. And it's not their fault for not fully understanding that. And then I wanted to make a second statement with the problems that I also have with keeping social media as well, is that social media fosters a culture where children are forced to hurry up their growing state, their adolescent and preteen stage, and forced quickly into being a teenager of like 18 or 17. And my example would be the story of the recent Netflix story, K-pop Demon Hunters versus Frozen, because in 2013 to 2015, when Frozen came out, it was all over everything, Frozen in the shops, Frozen on the TV, wherever. And whereas when K-pop Demon Hunters freshly came out, I think after 2 months of it coming out, it became a thing of, it's annoying, it's not that good of a show, I don't understand why kids are watching it. When I was a child, Frozen was encouraged everywhere. We'd learn everything Frozen. The teachers would add Frozen into all the lessons because that's what we grew up with, and it's something that we'd really love to hear about. Whereas now, if a child says, oh, I love K-pop Demon Hunters, it's going to be a thing of, oh, I'm sure this child's annoying, and it's going to make that child want to grow up and say, oh, you don't think what I'm watching is cool. What do you think is cool? You think this is cool. And that's my issue with keeping social media. And as well, the consequences of the ban. So we decide to ban social media. So a child grows up until 16 without social media. And in my mindset, when I think of that, I think of people who grew up in the 2000s where social media was there, but it wasn't as popular as it is today. So they would grow up with a more outgoing spirit, more outside, more vocally speaking, more independent in all their thinking. And then now when they get that access to social media is known as the place of a hive mind, where a popular phrase used is unpopular or popular opinions. And then now everyone thinks that their opinion that they got from social media is something not thought of when you got it from a popular social media source. And now when they get on social media, it's going to reduce their independent and unique thinking and standpoints on social ideas and news in the world. And then to effectively see the results of the ban, we're going to have to wait at least 16 to maybe 20 years now, because already with Generation Alpha, which I think is from ages 2 to ages 10, I think, because that's the age of my sister, and she's in that generation, and they already have their things of brain rot with whatever things they say there. She's under 10. Yes, she's under 10. And they're already affected by social media because they grew up with a screen right in front of their face from the age of 1. So in order to see the actual effects of the ban, we'd have to wait 16 to 20 years for the new generation, which was born last year, to see, okay, if these kids grow up without social media and they reach the age of 16 and they get social media, what changes and how do they grow up now? How do they act? What's their way of working in the real world?
Sorry, yes? Did one of you have a hand? Oh, right, okay.
Okay, and I normally, when I'm confronted with these difficult things that I try to parallel, I don't want to say real life, but offline life and online life. Normally, in our villages and communities, we protect children. There's supervision, and it's easy to do because spaces where children are not supposed to be, it's easy to verify this is a child, this is not a child. But that's difficult online. And if what William is saying, that technology is able to know how old you are, isn't there a criminal case for platforms to answer to? Because they're not protecting children enough when they have the power to do so. And what's the analogy for the online protections that we afford children offline?
Just hang on a second. Who was that question for?
Okay. Thank you very much for the presentation. I think I really liked the lived experiences of the young people. It really makes it real for us. But I do have a question, I think, for everyone on the panel. So my question really is around this idea of banning or not to ban. Are we going with the trend because Australia is doing it, Spain has done it, France has done it, the UK now is looking at banning the mobile phones for children under 16 years old. So my question really is, have we suddenly developed an interest because we want to seem relevant as a country, or because we really care about the safety of children? And so I think that's really important for us to be able to define as a country, to say, are we doing this because we really want our children to be safe? That's the first thing. And then the second thing is around the umbrella ban. No matter how much we look at it, even from different angles, it's still going to be an umbrella ban. Because when we look at, for example, Australia, they've looked at banning social media, which when you look at research that's actually coming out of Australia, it's not working. But my question really, I think also as someone with the Gen Alpha children, what exactly does that mean for the younger ones who are not on social media platforms, right? But you look at platforms like YouTube Kids, which are equally as worse as TikTok, right? But we're not talking about that. So when we're looking at, even when we're talking about social media platforms, we're thinking Facebook, TikTok, Instagram, Snapchat, but we're not looking at other platforms. We're not looking at your AI chatbots, for example, Roblox, right, which is even more dangerous. We're also not looking at your gaming platforms, which is actually causing so much addiction among young people. So my question really is, if we are going to say banning or not banning, what frameworks are we going to put in place? And also, how do we contextualize it to South African children? Because we like, as a nation, as Africa as a whole, we love adopting European models and guidelines, which don't work actually in the African context. So how do we ensure that if we are banning or not banning, we are actually doing it for our own children as Africans?
I just wanted to add on to what the Miss said and what my fellow Article 12 members said in terms of, as Africa were adopting European practices. I also wanted to mention that in one of my testimonies earlier, but I just remembered this as well. I think it kind of doesn't make sense as Africa, specifically South Africa, to suddenly want to adopt something of this nature without actually consulting with the teenagers of South Africa. Because, okay, you have us, the Article 12, as representatives, but this is our own personal experiences. You don't know what the experience of a classmate of mine has, or someone in my transport might have, or my neighbor next door might have. We don't know what those experiences are. We're just putting this ban into place because, oh, the USA is doing it, France is doing it, UK is doing it, our next door neighbor is doing it. But are we actually considering how it's affecting our South African children? Because we're in different atmospheres, we're in different environments, we have different beliefs, different histories, we live differently. So I feel like that's also another thing to consider in terms of the ban. We can't just put something into place and generalize all children. Children have different experiences. We're all in different backgrounds, we have different opinions, and we grow up in different places. So to just generalize children in terms of one thing and say, oh no, we're protecting children, but you're not considering how this might affect them, and considering all groups, not just a group of, I don't know, how many of us? 8 of us here, instead of maybe consulting the millions of other South African children who are using social media actively and how that can also affect them. So that's something I wanted to comment on.
Thanks so much. And is there someone still desperately wanting to? Oh, William says no. Okay. If everybody's happy then for us to move on to closing arguments, we'll have 10 minutes each for you to have closing arguments.
May it please the court, I will now use my 10 minutes to address this court on 4 points. First, that we are not banning the internet, but certain social media platforms that have been shown to perpetuate harm. Second, I will look at why regulation has proved to be ineffective as a current response, why the current ban or proposed ban will still ensure that the benefits of the internet can be protected, and then I will close. At the outset, I noted that the ban will not solve every problem, but rather act as the starting point. I may have not made this point clear in my initial presentation, but platforms need to understand that states will not sit idly by while a generation of children are exposed to psychological trauma, with effects that will still be seen for years to come. In response to the questions posed, this isn't a trend, it is a coordinated global response. We are banning social media platforms that refuse to implement safety by design. As I mentioned, the case of Molly Russell took place over 5 years ago, and 5 years later, the same platforms refused to implement design features that would protect children from the same type of harm. Looking at the benefits that we have mentioned and that the Web Rangers spoke to, for example, Australia did not ban WhatsApp. This means that children are still able to share ideas, communicate, and engage in educational tools. For example, a ban could propose that children retain access to educational content, communication tools, and supervised digital spaces. This isn't about excluding children's voices. It is about ensuring that these voices are heard in safe spaces. In closing, my learned friend and many of the questions have asked this court to trust that self-regulation, education, and parental vigilance will eventually solve the harms that we have put before this court. However, the case before us must recognize reality. The evidence of harm has been documented. The vulnerabilities are only developing more. The platforms are structurally incentivized to prioritize engagement over safety. Section 28 does not permit us to be passive when it comes to children's dignity, safety, and psychological well-being. To speak to the concerns around privacy, I submit that there are 2 concerns that need to be looked at. As we've mentioned, platforms already contain or control a huge amount or immeasurable amount of data. The argument put before us in favor of a ban does not propose that verification measures make use of facial recognition or other data. Those considerations do require a much more thorough human rights analysis. However, privacy concerns should be looked at in terms of the platforms that already hold that amount of data. In conclusion, I would like to reflect on a quote that I've heard that the Web Rangers echoed too. It says, "The day you hand a child a phone is the day that their childhood ends." We must protect our children, and a ban, I submit, is the best way to start.
So throughout the process of this discussion, we have had to play sort of a balancing exercise. We've had security, dignity sort of on one end versus freedom of expression, access to information, with Section 28 being the best interest of the child at the center. What I propose here is that we do not have to compromise one for the other. Less restrictive measures can be imposed without diminishing children's voices. Will it be hard? Definitely. But whatever we do, we should not want, the solution cannot be imposing a ban that excludes children from an environment that they will ultimately have to re-enter without addressing the root of these online harms. We have had this conversation before. The social media data center in January 2026 collated feedback from a couple of child rights experts. Dr. Holly Beer and Dr. Chris Ferguson from Oxford noted that we do not have enough information to determine or to determine that the sole issue for for the harms that we are seeing can be attributed to social media. Dr. Chris Ferguson went on further to emphasize that we have seen this over and over again. Now, while I was not around at the time, this issue has been prevalent with gaming. It was prevalent with magazines, it was prevalent with TV, it was prevalent with rock and roll. And clearly, the issue may very well not be the medium that is used, but a deeper psychosocial and societal issue that we have to unpack. And this speaks to some of the arguments and some of the points that were raised in the panel. What may very well be the issue is how society has been conditioned to interact with media, different forms of media, and with each other. We have underlying issues of misogyny, gender-based violence that we have to address. Banning social media does not do so. We've had this conversation before. Moreover, and as pointed in the panels, that we have to adopt an African lens to this. We have to view these problems for what they are. We cannot impose and take from what we see in the West and assume that it will work in South Africa. It is simply impractical. And on the issue of practicability, we don't want to have a situation where children move from platforms that are definitely doing a terrible job, but can still be held accountable to those with zero oversight. And again, an intervention from our wonderful web rangers is that when children could not access TikTok, they then moved to a platform that had zero oversight whatsoever. You can still, to some extent, you may not win, fight Elon Musk and Zuckerberg, but in an instance where there is absolutely no oversight, what do you do? Where these harms aren't even brought to light to begin with. This isn't an alcohol and cigarette scenario, because children will inevitably be led back into these platforms. And to reiterate, we do not want a situation where, as rightly pointed out by my learned colleague and by the judge, where technology keeps evolving very rapidly and children are not exposed, and I like the term of exposure therapy, where children are not exposed to the ways in which technology is developing, and then are brought back into these spaces at 16, 17, they're still children, but now have to now deal with these harms because we have failed to address them because we thought a ban and digital literacy with zero context was sufficient. And to answer some of the questions from the panel, one of the questions that was asked was on information integrity and AI, hallucination, etc. Again, very important issue, but LLMs are in emails, they are in Google, they're embedded in everything. We do need to address these issues. We do need to hold these parties accountable, but we cannot then ban everything. The other sort of issue that came out with was whether or not we should hold platforms criminally liable for failing to act on age verification markers that they already have. Definitely, we should go against these platforms. Again, we can go against these platforms without diminishing children's voices and removing them from these spaces. We do want to hold platforms accountable, but we do not want a situation where children are excluded from digital spaces as a result. Holding platforms accountable as well has its own assumptions in place. It assumes that we are in the same space as the European Union. It assumes so many things, and that is why we have, in addition to platform accountability, have proposed other mechanisms, safety by design, for example. And lastly, we just need to be careful. We do not want to enter into a space, or we do not want to be in a situation where the minds that are meant to sort of lead us, the minds that are meant to have the greatest voice moving forward are diminished. We do not want to have a situation where we, as the adults, are making decisions for children without their input. And we do not want to have a situation where children are removed from these social media platforms, are unable to engage meaningfully with each other, are unable to impart information, and are unable to critique the issues with the social media platforms that they're on, just because a ban is easier. If there are no questions, that concludes my submissions. Thank you.
Okay, thank you very much. We're going to have a 10-minute break. So I don't know. Oh, right. So do people have to stay? Okay. No break.
So, this, thank you. Okay, I think our excellent, you can all sit down now. I mean, that's very kind of you. I think our excellent lawyers deserve another round of applause. That was really, really cool. So we are going to do this now. When we did it the first time by the manual method, a show of hands, we had about a 50-50 split around some of the questions. So it's going to be interesting to see where we go. But I understand the link has now been fixed, so I would ask you to please scan the QR code. Let's see, young people with their phones out this time, they have them already. And to now give us a word or phrase that comes to mind when you think of children or teens and social media. Is it working now? Yes. Yay. Okay, I'm going to do it too, actually. To show you how easy it is. Right. You can do it if you want to. Okay. Why are we not seeing any responses, Willa? Oh, you have to do the whole form first, right? Okay, you've got to answer the 3 questions that are there. Question 1 is a word or a phrase. Question 2 is, do you think we should be banning social media? If any of you have changed your mind, that's a good thing. It means one of our legal team was particularly persuasive. And then the third question is what should we what should we be doing as Moxii Africa in relation to these things? I wonder how Thabo voted on these questions. Can't make fun of him. Thank you for being with us. Right. Okay, there we go. Ooh, that's quite sexy. Okay, we've got... Oh, fine. I'm going to move that there so that when Judge comes back, she can... Dangerous and unsafe, danger. TikTok, ban adults. I mean, that's maybe not the worst idea, right? Imagine how much better our world would be if evil forces like Donald Trump, Elon Musk, imagine if they weren't allowed on social media, or that you give them the pretense that they're on social media and just let them send it between them, cycle it between themselves, their pedophile friends and their evil Barbies. Right? All of their lies and whatever, and just let them sit, like give them a walled garden to play in. That's probably what we should be doing with them anyway. Please ask your engineers at Meta to look into this if it's possible. Thank you. Right, okay, I think people have done that. Let's move on to section 2, question 2. Wow. Okay, the maybes are really, really interesting. Okay, I want to say, I want someone who's prepared to say no, to put up their hand and tell us why. Anyone? Yes? We've heard from you. But it's okay. Briefly, though. Why shouldn't you say no still? For the reasons you articulated earlier. Okay. If you can say them in 20 seconds or less, then yes.
We shouldn't generalize the experience of social media. As my school told me, because my parents are very protective of how I was on social media. I use kid platforms like YouTube Kids, and I don't have Instagram. I only got TikTok when I was meeting the age restrictions and all of that. And again, with Ms. Smuts, what she said about investigations, how Australia's not using WhatsApp and not using WhatsApp in their banned, in their banned social medias, WhatsApp is not included because that's a place where people need to communicate and all of that. And the excluded social media platforms should be the ones that provide education, and digital platforms should be supervised. I think that's also really important. And then with what Ms. Sekati said regarding, I still really resonate with her statement of not using European solutions to African problems, because a huge South African problem is the gender-based violence we face in this country, and that is a big contributor and factor to that is the way that culture raised men. And now if you allow social media to continue and to let social media raise children and change the perspective of men in culture to you do not have that power to abuse a woman. Now social media can really help change that factor and raise men in the way that they should be raised, so that GBV can be lowered and all of those factors.
Thank you. Those are excellent points. If only we could get social media to agree that they should be working to counter gender-based violence and not actively encourage, support, endorse, construct, recreate, celebrate, and reward gender-based violence. Not that I'm referring to any platforms in particular, but X might be one of the obvious examples. Okay, anyone who says yes, we should ban, who's willing to put up their hand and say why? It's okay. It's not like you're admitting to being in the Epstein files. Nope, no one willing to say why. That's interesting. Okay, who said maybe? Were you willing to say why? Okay, 20 seconds or less.
Yeah, as I said earlier, I think it's a blunt instrument, but I think we have to do something. And I do think that, thank you, that as the rest of the world actively engages with making these choices, we just open up ourselves as a market to these social media companies to just flood us with all their harmful content unless we actually draw a line in the sand. So as much as I think maybe there are better solutions, I don't have one right now, and I think it's a good starting point.
Right. It was a very powerful yes. Okay, anyone who's a maybe? And if you are a maybe, I want to know why you're a maybe. Yes. Lady in the white jacket.
I'm mostly a maybe because I'm their boss, and it would be awkward for me to pick a side. It's like picking a favorite, and I don't want to do that at this stage. But I also, the question is too binary as well. There's so many classic lawyer answers. It really depends on a lot. But I did very much welcome a lot of the input on maybe it's a ban for children up to the age of 13, and then there's different restrictions up to 16. So I think there's a whole spectrum of considerations we can consider that are not necessarily a ban, but maybe limited access or different access that I think could be a more useful solution. But well done to my colleagues on stage. I'm super proud.
Okay, let's go to the third and final question then, which was, what do you think we should be doing now? Engage with the platforms, pressure and engagement, social media, media companies, support, engage platforms, design. Okay, lobby government. Anyone want to explain or any of their suggestions for that? Nope, you're all quiet now. Hey? Oh, there we are. Lobbying government and continuing. Act, constant engagement with platforms, ensure children are protected when using social media. Engage policy media, monitoring, continue the conversation. Draft new regulations that are responsive to current social media issues currently experienced. Make sure social media platforms use measures such as AI to protect them. There should be a roundtable of platforms for government to forge a way forward. Name and shame social media, make transgressions. Ultimately, they're only in it for the money. Push safety by design, engage platforms for support for teens, ensure safety by design, ensure stricter protocols, engage them, advocate for legislative change. Wow, these are really cool. Support government setting up an online safety authority. That's an excellent idea. I mean, I'm saying that because I'm biased, because that's currently what we're pushing for, actually. So, push for accountability as well as progressive engagement, work with platforms to promote safety features, take on big tech, and litigation. Oh, good. I'm glad we saw litigation. You'll be pleased to hear that we're doing most of those things. And that is a perfect way to round this up. We're now going to welcome back Judge Karina to give us her something in relation to this case. You can all rise again, just sticking with protocol.
I'm very pleased I can contribute to your cardiovascular functioning for the day. Okay. First of all, I'd like to say thank you very much to the submissions made by both representatives. I think that was very helpful. The thing about being judges, which I hope they appreciate, not me, because I'm not a real one, but the real ones, is that, you know, no two cases are the same. They're always different. So you always have to learn new things. So I can just see if there is a case about this in the future, all of the acronyms and alphabet soup and explaining to judges all of how this all works. Because I can tell you now, they won't know. And I know because I don't know. And on the face of it, it appears to me that censorship is always bad, and that's because I'm from the 90s. And in the 90s, you know, I was in high school, and we had just become free, and books were unbanned, and television was more accessible. And so, to me, anything that even smacks of censorship is sort of instinctively bad, and I don't like it. There were no cat memes in the 90s, I just want to say. You had to have an actual cat for joy. Though I would recommend that in any event, at all times. But it seems to me here that the key is going to be to make any assessment of whether there should or should not be a ban, and whether what the extent of that should be, which has to be child-focused. This is not an aspect of the law that will impact anybody except children. In other words, an adult's not going to be subject to the same restrictions. An adult won't be affected by it. We'll go on with our free internet reign or social media platforms or whatever. The only people who really can say what this will be like and what the impact will be are children. And so it seemed to me that one of the insufficiencies in both the applicant and the respondent's case is that there was a lack of consultation. And I would really like to say, both from Oratile and Mulai, thank you very much. That was very interesting, although I must say, Mulai, you seem to have convinced yourself to the end that there shouldn't be a ban. So I'm not sure what your position is, but I found it helpful to understand the complexities of it, the sort of interconnectedness of how dependent you are on it, but you can recognize the inherent difficulties in social media as well. And that is perhaps the constant struggle of it, is that it is both very good and it can be very, very bad. So yes, so as the court, what I notice is that at the moment, I think there is insufficient consultation. We cannot have consultation based on 2 expert witnesses. Second, both the applicant and the respondent admit that this is a balancing exercise. And the balancing is between children, the need to protect children and their evolving capacities. And this balancing exercise of guiding them while at the same time recognizing that as they go from birth to adulthood, they're constantly developing, and so the rules need to be adapted. But children, of course, also don't develop at the same ages, so we are, as lawyers and as lawmakers, stuck in a position where we do have to draw arbitrary lines. We do have to say something like the age of 16 or the age of 12. We can't accommodate variables according to each child, though I suspect social media might be perfectly able to do that. So just from listening to both arguments, I think I at least, so very, very inappropriately put up my hand to say I oppose the ban. And as the court, I would say we're going to take the cowardly way out for now. I don't think there has been sufficient consultation or consideration of all the facts. I do think that there hasn't been sufficient consideration for the right to self-expression, as well as the right to freedom of association, which is, I think, what Oratile talked about finding a sense of belonging, finding your community, finding your people, basically. And I think we underestimate the importance of that while we're looking at protection. And so I think what I was looking for from both of you, perhaps when I was being difficult, was I wanted to hear freedom of association and freedom of expression, because I think some of the very positive aspects of social media is the platform they give children to really live sort of, they might, you know, get some snarky comments, but I'm reliably informed you can put off comments. I don't know, I have never posted anything other than a cat picture. And so what this court's decision is in the end is that there are very serious reasons not to consider a ban, but there are also very serious reasons to be concerned. And so to that end, I think this court will order very bravely that government must go away and come up with a plan, which they must present to us within 2 years, of how they intend to deal with this. So what I've come up with in the end basically is nobody wins and nobody loses, but I hope that everybody learns something. Thank you very much. Can I sit down now?
Again, A huge round of thanks to our judge, Karina, to Penyo, and to Sophie. One more applause, please. We're going to make some of these summary decisions available. We're going to gather for a group picture on the stage. There is a lovely lunch outside that I would encourage you all to please go and enjoy. But before you do, please just wait for the people to have their pictures. We need to get our young people and our legal team to eat first because they've got to shoot and leave and eat because they've got people to sue and documents to do for Moxii Africa, among other things. So yes, we'll just gather for a picture, but thank you very much, everyone. There'll be some more events coming up in the next short while. Our Media Freedom Festival, we'll be back here probably, we hope, in October, but there'll be about many events between now and then. We will be having, in relation to some of the suggestions that says roundtables, there will be a roundtable discussion, a closed roundtable discussion happening with government departments and the social media platforms. You'll be getting your invitation as soon as I get some potential dates from our Department of Communication. You'd be pleased to know that I think the Minister would have been watching us had he not been in Parliament presenting, because he was curious about getting a summary of this. So stand and mill about if